Yeah.
Um, Albertina, if you're ready, we can start.
Okay.
Okay, thank you so much, everyone who's joined us today. We are really happy to have Albertina Almeida with us, whose work we've been following quite closely for our work as part of the project on unpaid domestic work. Albertina is a lawyer, human rights activist, and independent researcher, in addition to being a journalist and a teacher. She is based out of Goa in India. She holds a PhD in law, and the subject of her thesis was matrimonial property rights of women under family laws of Goa. She's also co-founded several initiatives such as Bailancho Saad Angan, Citizens Initiative for Communal Harmony, SEZ Watch, and is a member of the Al Zulej Collective, and also of Social Justice Action Committee Goa. She was a member of the Permanent Lok Adalats for North Goa for almost 2 days, and a member of the Family Law Review Committee to review and update the family laws of Goa. Today, Dr. Almeida will share her experience about the operation of equal matrimonial property rights in Goa in respect of the ownership of property across religious affiliations, which is something she has written and spoken about very widely. Yeah, over to you.
Thank you. So I will share a presentation, but before this, I want to say that since I'm based out of Goa and there is this current debate on the Uniform Civil Code, so I come from a slightly different location, being based from Goa, and that is something that I want to flag at the start itself. Uh, it's not the same as in the rest of India in terms of the laws that are applicable. The presentation is visible.
Yes, it is.
Yeah.
Yeah.
Okay. Thanks. Yeah. So, since there's so much of this stress on uniformity, I thought that it's important to look at it in the context of social reproduction and matrimonial property rights. Whether uniformity across religions or uniformity across genders per se means anything. Like, so for example, if you have equality between the gender or a gender neutral approach, as they call it, without equity, whether it can mean anything. And this is in that context, this is my presentation. I'm drawing from my experiences from my experience as a true legal practice, engaging with women who who, wading through the legal system with them, women who come to consult regarding prenuptial agreements initiated by the other side, women not allowed to enjoy their marital home or other matrimonial property by their in-laws, collating notes, research questions, as part of my PhD thesis, deconstruction of various concepts, reconstruction. Um, Also, in terms of activism, and that of course provided me access to a cross section of women, because a lot of women don't even end up accessing the law, the legal system, but they have issues of property rights and recognition of their the or rather the lack of recognition of their social reproduction work in when it comes to matrimonial property rights. And of course, in teaching, when you're teaching, each time students ask you different questions, and that makes you think about various other concepts, and even sometimes an intersectionality with, concepts not usually discussed or used in family law. So, of course, as I said, I work out
Sorry,
of Goa.
Albertina, just 1 minute. I think some people are not able to see the slides, which is odd. I think, let me do one thing. Yeah, just give me a second. And is it visible now? Are the slides visible now?
I don't, you'll have to see from the participants. Yeah, yeah.
No.
No, Anne?
No, I'm so afraid not. It says we'll let people in the meeting know you're waiting, so I can hear you all, but I can't see anything. Perhaps I'll log in again. Sorry.
Okay, sorry about that, Anne. And Sally, are you able to see it? Okay. Copies of the slides. Okay, that's up to Albertina. Yeah. Albertina, would you be able to share the slides later?
So I don't, I'll not, I'll disconnect. I'll not.
Just stay on. I think
Okay.
the other, are you able to see the slides? Is everyone having the same problem?
I can see it.
Yeah, I'm also
Okay.
able to see it.
Okay. So I think it's probably just Anne. Okay, so I think you can carry on in that case, Albertina. Sorry about the interruption. I think Anne couldn't see them, but she's going to rejoin.
Okay. Okay.
Yeah.
So as I said, I'm based out of Goa, and it has a different historical trajectory from mainstream India. It was a part of Portugal when the Portuguese Civil Code was enacted in 1867, and the code came to be applicable to Goa from soon after, when it was extended to Goa, since Goa was considered part of Portugal during when Portugal was ruling Goa. So the Indian Parliament enacted a Goa Administration Act, by which some laws applicable in the rest of India, that is laws which have religion-based application, and the secular laws in India were not extended to Goa, since the Portuguese law was assumed to be uniform. Now the thing was that this was in when they were discussing this in 1962, the Parliament felt that there is a imperative of uniform civil code in the Constitution, and here in Goa we already have it. So why let us regress as far as Goa is concerned? So that was the logic with which the uniform civil code, the family laws prevailing in the other parts of the country, that is whether it's Hindu law, Muslim law, Christian law, or whether it's the Special Marriage Act or anything in the rest of the country, was not extended to Goa. So by implication, the law said that anything where there is no corresponding law extended from India to Goa, then the local law will continue to prevail. So, so I mean, that's fine, but there was no, it was in this whole process, it was made out that there are, it's as if uniformity means means equality, and there's absolutely no discrimination, and it's the best thing for women, for marginalized sections of society. Rather, other marginalized sections of society were not talked about. Other marginalized stakeholders in the family were not talked of, but I suppose it was imagined that it would be equitable for women. It also had some provisions which were seemingly equal as far as women are concerned. For example, sons and daughters have equal rights to parental property in the law in Goa. And also there is this concept of matrimonial property, that is of holding property, whether it belongs to this wife or the husband before marriage, inherited by her or him before marriage, or whether it was gifted or acquired in any form before or during the marriage. It becomes part of it is the marital property, and it is held by the couple as an unit. So this is the system which is called communion of assets. This is the kind of default system in the Goa law. That means if a couple signs up, registers their marriage, and they say nothing about how they will hold their assets, they just sign that form for registration of their marriage and do nothing else, then it is automatically assumed that they have signed up to this communion of assets. So here is where iniquities begin at to start with, because one, um, women are not conditioned to look into all these legal aspects, nor not that other people are aware, not that men are aware of legal aspects either sufficiently, but definitely there's much lesser access to information by women. And so what invariably happens, besides the social conditioning, that they shouldn't be looking at the marriage form, where some places the form may have a thing that you're signing up to this default system of communion of assets. So the thing is that many times people are signing into this system without knowing what they're signing into. Not that communion of assets, there is nothing whereby we can say that either communion of assets is a good thing or the separation of assets is a good thing. We need to look at the context, and we need to look at the special provisions that there are and the problems that there are, because it's equal across the genders. So which means that when it's considered marital property, it's the property of the couple. So it's supposed to be equal across genders. That means, it's not as if only the woman's property comes into the marital property, or the male spouse's property comes into the marital property. Here, before I proceed, I also want to say that I'm not discussing same sex, etc., because same sex marriages, or because marriage itself in the Goa law is defined as a contract between two persons of different sex. So there's no question of application of that law to same sex couples. So therefore I've not discussed that, but there can be implications of, if such a law is extended, what could be the implications would be something that could be discussed. So as I said, there's this default system, and this is called the system of communion of assets. But there are another two systems which are there there are another three systems, in fact, which are there in the law. That is, if people want to opt out of this default system, then they have to enter into a what is called a anti-nuptial or a pre-nuptial contract. And in that according to what they set out in the contract, it would be one of these three regimes. So the one regime, in terms of the way they can hold their assets, is simple communion of assets. By simple of communion of assets, it means that assets, only those assets inherited or acquired in any form after marriage will become uh, uh, you know will become common assets. Whatever was before marriage will be separate. by separation of assets is meant other ways in which properties may be separated. They may say X properties will be separated, Y properties will be held in common, or define it by the time of acquisition or before or after children, etc., in various ways. And there is this third system, which is the Dotal regime. Dotal regime means at the time of marriage, the inheritance is given to that particular uh, spouse, and therefore then they don't have a claim to their inheritance. And so in this regime, so then this is her inheritance, and this is something that she's supposed to have control over. And during I mean, once this is given, she cannot claim any rights to, he or she cannot claim any rights to inheritance. But strangely, this system, I have not come across any cases that were followed. I was told by a judge that, a judge who has retired about 25 years ago, that the only case he came across was of a priest where this system was followed, so that he would not be able to claim inheritance rights. So anyways, this is the fourth system. So these are the systems, but by and large, the default system is followed by default, if one can say. And if at all, there have been, when I did my PhD, I looked at Panjim Tiswadi, which means where Panjim, the capital, is located, and which is like would be the place which is more educated and may know something about anti-nuptial contracts. And over a period of 5 years, there were just some 5 prenuptial contracts. So, and those were all where one of the spouses was super rich, and there was a fear that the other spouse perhaps would automatically acquire property the next day, and there could be issues. And what if the person is seeking to get married only to acquire assets? So it's that notion that usually drives the prenuptial contracts very often. Um, and sometimes also pressures from parents if there's a love marriage, because otherwise they're threatened with disinheritance. So in this prenuptial contract, the couple spells out how the properties will be divided, whether it will be separation of assets that belong to the spouses prior to marriage, or whether it will be other forms of separation of assets, and how, as I said, and or whether the property is given to one of the spouses as inheritance at the time of her marriage, where she has no further claims to inheritance upon the demise of parents, will be exclusively hers. Now, the backdrop of the prenuptial contracts, they have to be signed before the special notary. That usually in common language is called a registrar's office. It's the same place where the marriage is registered. The same authority before whom the marriages are registered. So it cannot be changed after marriage. It has so the fate of anybody is sealed at the time of marriage. So if you have to enter into a prenuptial contract, it has to be done before registering the marriage. And the practice is it's usually thrust on women after everything is finalized and just preceding the registration of marriage. And there is a provision that it cannot be contrary to law. And I'd like to revisit this point a little later in the course of the presentation. Um, of course, before we look at everything, we need to be conscious of the fact that, of course, that marriage is universal. So people, I don't know, even if they have choices, what are the choices they can exercise really in a situation where women are conditioned not to look at even their marriage registration form when they're signing, because that's considered as a lack of trust. What choices can they exercise, given that marriage is universal, given that there is an asymmetry generally in the relationship, given the fact that there is lack of knowledge of procedures, and if if at all, maybe the male spouse could be encouraged to find out about procedures, but certainly not the female spouse. Even any move to find out about the procedures would be considered as social as displaying a lack of trust and the lack of knowledge of options. She doesn't know that there are options, that she can opt out towards the system of communion of assets, or she can enter into a prenuptial contract, or that she cannot enter into one after marriage. These are things that are not known to almost all women, and there's no education of this procedures, or any legal counseling. By that I don't mean the general counseling, but in terms of legal information being provided to the couple prior to registration of marriage, or information being available to people generally. um, from there, I want to get into also the issue of time use in house and care work. Like everywhere else in the country, or perhaps in the world, women spend about from the women that from the case studies of married women that I looked at for my thesis. On an average, women spent around 8 hours of the day in house and care work if they were working outside the home, and around at least 12 hours of the day in house and care work if they were homemakers. Now, the work varied, the kind of work they did in terms of house and care work varied depending upon their levels of education, um, and um, uh, and proximity to the school of the children, or proximity to their workplace, and various others issues. But it involved work like taking up lessons of the children on getting up in the morning, preparing their tiffins for recess, dropping and picking up children from school, shopping, cooking, cleaning, sweeping, swabbing. Okay, in cases where they were economically, where the women were working outside the home, or were economically advantaged, the last three, that is cooking, cleaning, sweeping and swabbing, were done by domestic helps, but under the supervision of the female spouse. And then in many other ways, they have been also involved in maintaining the house. I just want to take you through some voices, in the face of these these laws. Um, I want to take you through some voices of what women have been saying in terms of their lived experiences. So there was this woman. Okay, I have to make it clear that these are not their real names. These are just um, um, uh, these are concocted names, but the point is, I've only sort of tried to put out so that you get a sense of the religion of the person. So here's the case of a Catholic woman. She says, I thought I and my husband put together decide everything about our properties, but I got a rude shock when he leased out our flat to someone for a song after he convinced me to go to my mother's place and take some rest. So the point is that, since it's not possible for a person to sell the property, since it's common property as per the default system, what what normally happens is that uh, they try to find other ways of circumventing. And yes, there is also an unequal provision in terms of control of the property, because the provision in the law is that although it's common property, and the argument used to be, you can't have two chief ministers, so one person has to have it, and that has to be. And so the law says that the management of the property shall be the prerogative of the male spouse. So therefore, unless the male spouse has what is called an impediment, and on account of which a female can manage the property. So that this means that, for example, he can enter into a lease agreement without the consent, without the involvement of the wife, whereas vice versa is not possible. So if, since he cannot sell a property, for example, he can decide to enter into a long lease of the flat, which is as good as a sale of the property. Or and first, after getting her to leave that place, if that is the marital home, and then, so there is no marital home to come back to. So now, yes, there are options under the domestic violence laws, in terms of her um, her right to a residence. But it's one thing to have a right to a residence, and it's another thing to have your own right to your own home in which you have been staying. And then here there are third parties now involved because there is a lease signed. So the whole thing is, I want to emphasize here is that it's not enough to have ownership. It's also about who has control over the property. That's very critical. And there are these illusions that we have this uniform civil code. Yes, the marital property law is applicable across religions, irrespective of religions. As I said, it's across gender, but it works out unfavorably for women because we live in a patrilocal society. So a woman moves generally to wherever, whatever is her husband's either ancestral place, two generation house, if not a more generations, and or to wherever the husband is staying. That is usually the case wherever the male spouse is staying. And so it is she who adds a lot of value to the marital home, whereas there isn't a corresponding addition to the the properties that she inherits. So what this means is that there is this asymmetry because of the societal patriarchal patrilocal standards of residence. So therefore this works unevenly for women. um, Here's a woman who this is a Hindu woman. She bought a house with her savings from government service, and this is in the way she puts it. Plus, I brought up our only son alone, and he came to claim for a half share in that house because, irrespective of what it is, this is gender neutral, right? So she buys, she's a government, she's somebody who works in a government office, so she's able to get a loan, but or she's able to buy it out of her savings. If she has to get a loan, she will require the signature of her husband because bank loans require the spouse's consent because of this the aspect that properties belong to both. So that's a provision which is there in the corresponding banking law. But if it's out of her savings, then she can just go ahead and buy it. Now, once she buys it, even if she buys it in her name, it belongs to both the spouses. And if there is a problem and there is a division of assets, then he can claim half 50% of that house. He can also manage that asset, although it's bought out of her savings alone, because whether or not it is hers or whether it's bought of irrespective of anything, it is the prerogative to manage the assets is of the male spouse. This is a Hindu fisher woman. So I get up early in the morning at 3:30 a.m. to go to buy fish from the trawlers to take for sale in our market, sell it, and reach home at 11:30 a.m. after buying the requirements for the day, and then cook. I get the service people in the house and pay for their services. By this she means because the fishermen are out at sea, and generally in a fishing household, a woman is seen as a more powerful. But here's where the property where it all falls apart when it comes to property. She seems more powerful, so she's the one who's very active, managing things in the house, managing as in physically managing things in the house, gets the service people if there's something to be repaired, tiles to be replaced, painting to be done. She'll be probably the one who will be kind of active and get it all done. She'll probably be paying for it from her earnings. And she says, after all, we're all staying in that house. But the fishing boat is in his name, the house is in his name in the panchayat, the property is in his name, and he's spending his money on the other woman. So whatever money that is saved now, because she's spending it all, she's doing the housework and she's spending it all, and whatever money is saved it is he's spending it. Of course, that's the other thing, that women often bear up with a lot of cruelty, but only get begin to assert their rights or assert their spaces when there is another woman involved, etc. So these are the concerns, that this is how things actually play out. And then since he can't in effect alienate the properties, or alienate the property in favor of the other woman in his life, or in favor of anybody else, or exclusively in his name or in his family name. What he does is, he doesn't in effect contribute, and all his savings go towards purchasing assets in other people's names. So it's about a long litigation if one would want to really go up that road. It's as it is, even this is like filing for divorce and filing for matrimonial property rights by itself can be pretty long drawn. So if it's about going up the road about benami transactions, etc., it'll be a still longer road. They'll never see there's no light at the end of the tunnel to see, so to say. So these are the realities where which are not recognized in the law, and therefore this provisions of being equal across genders is not anyway the way to go. Uniformity across religions, uniformity across genders doesn't mean anything. In terms of expenses, also, now this is the voice of somebody who, it's a typical voice of somebody who is consulting when an anti-nuptial agreement is to be signed. Most of the times they do not consult when they if someone just thinks that they know a lawyer and they have to consult, they might as well just check it out with that lawyer, since there is a lawyer that the family knows or something. Then they end up showing that, because even that is otherwise considered a bit shameful to be consulting somebody about marriage related matters, so especially for women. So here is so here's a voice. So she says, my fiance is suggesting that I sign an anti-nuptial agreement. Anti is in pre-nuptial agreement. The word anti is also used. That all our property shall remain separate. Whatever I buy or inherit will be mine. Whatever he buys or inherits will be his, he says. He has asked me to leave my job. So now the point is, there's this additional factor that you very often, especially if the family can afford to live on one salary, the woman is many times asked to leave her job. So at the time of marriage. So now, one, she's left her job. Next, she's left her parental home. She's now a housewife or a homemaker, as we call it nowadays. But women call themselves housewives. I do all the housework, and he doesn't have to pay for a servant. That's the domestic help. And he will have the money to buy the property in his name, but I won't have any because I'm not earning. So what sense does it make that his properties, well, it sounds very equal. His shall be his, hers shall be hers, but eventually, in terms of the work she's doing, she doesn't have any earnings. And in the end, she's not going to be able to exercise this, really also assert herself in the anti-nuptial contract, because by the time this anti-nuptial contract is being signed, the whole world knows that she's getting married, and it's considered a shame to have withdrawn, because people will always say, oh, she kind of walked out of a marriage. Whereas these are not the kind of attitudes that there are when it comes to men. That has to do with social stigma attached to somebody, uh, resigning from going ahead with a marriage. Uh, Now that's all this, whatever I said earlier, whatever I shared earlier was about how women are speaking. You have to in my practice, I come across comments like these from no less than the judiciary. You will have someone say, a judge say, why don't you just settle? Let us not be greedy. she's been given enough to maintain the child. So like, let her be happy with having the maintenance for the child. Now, very clearly, maintenance is very separate from maintenance comes out of earnings, and it's very separate from the assets that the couple hold, whether it be land, whether it be physical assets, and so therefore, this thing of conflating maintenance with marital property rights is problematic. Or it will come from the other lawyer who will say he has worked hard, sweating it out to have the money to buy the car and build a house. She has been sitting like a queen at home because this work doesn't earn money and is not recognized. So it's like she's sitting like a queen at home. I mean, quote unquote. So these are the kinds of arguments you hear, and which find like a resonance in the form of nods from the judge, and either the judge, some statements will be made by the judge himself or herself, and some will be made by the by the lawyers with kind of an approving nod from the judge. And we today have something like alternative dispute redressal systems. As I mentioned, I was also a member of the permanent Lok Adalat for almost 2 decades. But and basically the system with the permanent Lok Adalat is that you just put a stamp to what the couple agrees to, provided it is within the framework of the law. So if the couple agrees that this is how they shall hold their properties, and they're not there's something illegal about some illegal incomes or whatever specified on paper, so to say, then it's fine. So there are pressures on a woman to settle it. Now, why are there pressures on a woman to settle? This is because what invariably happens is, uh, just as she has rights to his properties, he has rights to hers. Now, one would say, oh, why not? But the point is, he's made no contributions whatsoever, by and large, given the patrilocal status, her parental property from which, parental home, for example, from which she's moved out to settle with so-called, quote unquote, settle with her husband, is not is not in any way contributed to by the male spouse. It is the brothers who live there who probably make some improvements, but he has a right to a share as along with her. And this means that she will not, meaning she is put under pressure from her family that we don't want this stranger now claiming our, because this person will become a stranger after divorce. So we don't want him claiming a share in our property. So you please don't make claims to his properties. So this is the kind of pressures there are. And these are the dangers of a law which is equal across genders and which does not take into account the fact of patrilocality, the fact of patriarchy into account. Um, Here, I also want to say that very often when we are talking of matrimonial property law, I think um, we need to visit concepts that are not often used in the matrimonial property law. At least in India, they're hardly used, or I've not come across much. I've come across little use of such concepts. These are used in other contexts. But I think even in the contexts in which they are used, we need to revisit these concepts. Like what is, often it is argued that she was a poor woman. She came into this marriage, just she didn't have anything. There were no properties that her parents had. They were tenants in some property, or what we call munkars, like caretakers of some property, and to which she loses her right, by the way, upon her marriage to that parental tenant, munkar property. So then she was this poor woman who came. She didn't have any house. She didn't have anything. She hasn't brought anything into this marriage. And 15 years down the line, now she wants a divorce. And now she's going to get half of my properties. This is how it is put. reflected. But again, so the whole the whole contribution to the housework, the care work, even the financial contributions that are made by her because of patriarchality, all this is totally overlooked. So one doesn't see the unjust enrichment that has happened in terms of acquisition of additional assets over on account of the social reproduction work being done by women. The surplus that her husband has been able to get because of her because of all this work that he has done. And here, so this is in some ways an unjust enrichment in a different way, but it's this unjust enrichment is looked at again. The concept is analyzed with male eyes, and same with undue influence. One has to begin to look at undue influence in terms of very often a woman, while she's during the marriage, she's made to sign, because property, as I mentioned, land cannot be alienated without her signature, without she also executing the sale deed, mortgage deed, or any document. So when things are good, she's there is she cannot, even if she thinks that it's not a good investment, for example, she cannot say no. For example, if they want to set up a corporate entity where they want to develop the lands, that the properties that they have, or in some form they want to transfer they want to deal with land, then she cannot say no to this at the time of when this is demanded of her. And before the tensions and the other issues have arisen in a big way, so she's not able to assert it. And so what invariably happens is there is an undue influence in alienating the properties during the marriage. So then she cannot make a claim to those properties because they're already alienated. So there is no question of claiming half or etc., because they do not belong to the couple anymore. So I think that one has to recognize the social reproduction work, the housework, the care work done by women, because and to build in these aspects into the family law, because otherwise simply being equal across genders will actually, in a patrilocal society, will translate into inequality for women. There are also other issues like lack of knowledge, because even if there is a house in which they're staying, they will not, very often we do not know our house numbers, because house numbers are just not known in especially smaller societies. People know the ward in which you are located, or if it's a property, you do not know the survey number. Nobody generally knows the survey numbers unless there is a litigation and one gets into that litigation. So they have difficulty to list assets. Sometimes they're not indicated also about some assets. They vaguely know that there are these assets in some places. So there is a problem with listing. They have difficulties in listing the assets. There are no enabling provisions. So if she doesn't list the assets, she doesn't become entitled to half of those assets, because they have to be listed for the inventory to be done and the partition to take place. And if he remains silent, there is no automatic provision of if he says that he doesn't have assets, any more assets, there is no automatic provision for perjury. It would mean filing separate proceedings if that should arise. To list incomes also, there is no enabling there is no enabling provision. And similarly, when it comes to accessing justice, yes, she can avail of a free legal aid lawyer, but there is much more to accessing justice than simply availing of a free legal aid lawyer, which means a kind of an enabling, supportive environment in the courts, which is generally and usually lacking on matters relating to, at least relating to matrimonial property. So these are all the issues with a law that is equal, that is uniform across religions, and that is uniform across genders, but fails to be equitable. So that's therefore what my case is that housework, care work, and gender asymmetry need to be recognized in the family law, and there need to be adequate safeguards or provisions accordingly. Um, it's not about communion of assets or separation of assets per se being a bad thing or a good thing, but it's about recognizing and safeguarding, weaving in these safeguards into the law. Of course, sensitization of judiciary, because a woman is discouraged from, as it is, it's a long journey, a labyrinthine maze through which the woman is going through in the courts. And if the judiciary is not sensitive and makes comments like the ones I shared, then there is a problem, because then she's discouraged. And as it is, there are, as I said, there are pressures even from her family. One is because of the social shame, and secondly because it's like that whole thing of about being greedy, that then that gets projected onto her family. The family is like that, they're all very greedy people, etc., etc. It can affect marriage prospects of other sisters. There are all these, this like a chain effect. So therefore it's important to have sensitization of judiciary, I would say sensitization of society as well, as regards reproduction and care work, and the contribution of women to a household. Yes, we need to be mindful of the patrilocal status. The law needs to be mindful of it. And therefore, our pitch needs to be for equity. And for this, we need to demystify uniformity, diversity, equality, because diversity, again, you can have diversity, which is problematic diversity. So let us, it's not always that uniformity or diversity are the keywords, or so therefore, or for that matter, equality, if it's a bland equality, doesn't make any difference. So in this context, yeah, so it's so this is what I would end with, and I can share more as we go along, if there is time, and after your questions.
Thank you so much. That was really, really insightful. And yeah, I mean, so nuanced. I think you covered so many things. Yeah, now we can open up for a couple of quick questions. We don't have too much time left, but yeah. If anybody has a question, please do go ahead and unmute. And I mean, you can raise your hand and then I'll point out to you. You can unmute and ask. I think Sally has a question in chat. She's asking, does your presentation regarding communion of assets only apply to marriages in Goa or outside Goa as well?
So it applies to marriages, all marriages where the male spouse is a Goan.
Sally, you also have your hand up. If you'd like to unmute and ask, you can go ahead. If that has not addressed.
So even if it's a Goan based in other parts of India or anywhere in any part of the world, it applies to that Goan.
We also have a question from Professor Saptash. You can unmute and ask if you'd like.
Hello, Albertina. Thank you so much for the presentation. I had a conceptual question. So given the availability of cheap labor in India, we know that social reproduction work is not done only by the wife, but the domestic worker also kind of contributes to that. There could be a nanny. She also contributes to that. So then how do we take that into account while making this argument for recognizing the wife's contribution to the marriage? So then is it fair to say that a woman who has had paid help should receive less matrimonial property than some of the women that you interviewed in your project who did not have any additional help. How do we tackle that argument? I hope my question is, yeah, thanks.
Yeah, so what invariably happens is that when it comes to the even if the fact that there is domestic help, the woman is expected to, especially if she's a homemaker, uh, and even otherwise in many cases, because you have what is called the top servant, as they call it, who comes before she sets out to work, or when in timings when she is there. So she is expected to oversee the when it comes to housework. Now you were talking of the nanny, right? So that nanny is often paid for. If she's working outdoors, she's paid for by the by her maybe. Also, there is still a lot of work that still falls on the woman, even when there is a nanny. That is one thing. So I agree that there is a difference when it comes to women from rich households who can have a nanny while they are also, even if they are homemakers. But I think invariably I've seen this, that with all those facilities, the care work still falls on women. I know of women from such households who and even includes people in very high positions, even in different high positions, I mean, in across arms of government, where they are forced to take leave. They end up taking leave when, for example, the children are sick. Even if they have a nanny, there's a lot of there's still a disproportionate amount of responsibility on women. So therefore, I would say that it becomes very difficult to distinguish. Also, when there is a breakup, so to say, when there's a strain in the relationship, what invariably happens is, one of the things that the male spouse does is to pull out the support for the care work, for the nanny, or for the domestic help.
Anne, you can go ahead and ask your question.
Thank you. I think the other thing, just to add to that, sometimes the assumption is that men are solely responsible for the asset acquisition, whereas often there's more than one person involved in the processes of the acquisition of, wealth. When they're at work, they're supported. The idea that men are always totally autonomous in the creation of the wealth, whereas somehow women in the housework are always relational, I think is an issue. Behind, the man is supported in a number of ways. That's just a comment. To the way in which perhaps the way men the assets that men create are somehow seen differently created to the way that assets that women are involved in are evaluated. But I just wanted, it's just a really sort of a very lack of information, knowledge point. I noticed each of your examples didn't include a Muslim woman, and I wondered whether the issues in relation to Muslim women came up, or whether they were seen as separate, or to the extent to which Muslim women were using the Goan system. It was just a lack of knowledge on that part, really.
Yeah. So basically, I haven't had a Muslim woman seeking to enforce her marital property rights. And my sense is that there has been which also in some ways has been the case in the past with Christian women, because both the Christian and Muslim within the Christian and Muslim institutions, there are provisions. There are not provisions. What would I say? There are sort of there are institutional setups. So, like, a woman will go to a priest to intervene. and sort this issue out. Or a Muslim woman will go to, they have what is a community thing called the Jamaat. So here's the issue of legal pluralism, and it has helped them because rather than this long journey to identify the assets and make a claim, along with all those pressures that are there and the stigma that attaches to her of being this greedy woman, etc. So rather than that, she prefers to opt for those systems. I haven't even had them what you call saying we want to apply for matrimonial property rights, but meaning we want to seek this division of marital assets. Even if I have though I have dealt with cases of divorce of Muslim women, because and that divorce has been dealt with through the courts, because divorce is not possible in the Goa law without it has to be done as a civil divorce. So that cannot be compromised in any way. But when it comes to marital property, because of all so they realize that if she has to separate, she has to go through the court for a divorce. But when it comes to marital assets, they find these other ways to do it, because there are these institutional systems, and the usual thing is that the civil law system is long drawn. There's no community support. People don't want to come as witnesses, come there again and again to the courts, etc. So that's why I have been making a case for legal pluralism, because legal pluralism, whether or not it's specifically embodied, but there has to be a space for it. It cannot be discounted altogether, because these mechanisms do count when it comes to for people to sort out the division of their assets.
Thank you so much. Do we have any other questions from anyone?
I think Sally had a follow-up on the question of the husband being Goan. Does that mean he has to be born in Goa? Is that the criterion?
It doesn't mean he has to be born in Goa. It could be his parents or grandparents could be Goans as well. So this is based on both personal both personal and territorial law. This is. I really want to say that something that I didn't get down to mention was that I feel that the comments of judges are based a lot on their perceptions when it comes to property rights. So it also comes to also further get into your question, Saptarshi, generally about the larger wider concepts. So the judge is looking at this as many of the judges are from landed sections of society. So the judge is looking at this as you're working. So what if even if you try to argue that out, though we don't have to argue because the law is very clear. But when we are talking about it, because these comments are being made, etc., and because the logic. First of all, it's not clear what the logic was in deciding on these concepts of matrimonial property rights. And in any case, they're not in the memory of the Goa's system, because that was not a debate that happened, discussion that happened. It's not like the Constituent Assembly debates that you have access to, or the judges can access. So there's no memory of that at one level. And at another level, so they go by the memories of other realities and the links with other realities. So they're looking at so somebody who works can make a claim to property, kind of thing, that sort of thing. The ownership, the concept of ownership of property, and not use of property, the recognition of use of that property, the recognition of contribution in other ways to that property. This doesn't determine property rights generally. And so it's, that is why I had raised the question, which I didn't get enough time to discuss in this, was that whether, you can talk about this without discussing how property rights are posited generally, if we don't discuss that. But on the other hand, I also want to say that if you should, in some jurisdictions, in some countries, they talk of marital property rights as you compute it in terms of people's contributions. I would not advocate that. I would rather go by a generic thing because it's very difficult. It would be another layer in the long line of access to justice, to sit and be computing all this, and deciding who contributed financially, how much, what contribution was made financially, given that also all the other kinds of systems that we have in the country of how properties are bought and sold.
Sorry, I had a very quick question because you talked about, Albertina, the fact that the courts don't have any legislative debates to refer to. They have no point of reference essentially because it's a common law country. But just as we look to say English law, and often the judges will say, well, even in England they've changed this or that, and we need to keep up. What kinds of narratives of catching up, or is there something one can learn from the civil law implementation? Other innovations in family law in the civil law system, which could be then brought into, amending the Goan law. Are there any prospects for that? How does it work?
Yeah. So as far as I haven't come across, feminist critiques of the law as it was in Portugal. But the law in Portugal has changed, and the default system in Portugal is separation of assets now. But I'm not for that. I still think communion of assets is a good option, because in a situation where people don't have choices, real choices, I mean. So therefore, if that's the default system, they kind of fall into it because they anyway are contributing to the asset. All I'm saying is that there need to be safeguards and there need to be protections, and this concept of communion of assets needs to be redefined in terms of whether, considering the patrilocality.
Thank you so much for that. Do we have any other questions?
So, Albertina, just a final question. I just want to know, so, given the UCC debates, I mean, so what would be, I mean, you've given us a lot to think about, but, if you were to, a feminist sort of prompt for the UCC discussions, because obviously there are groups like Vidhi that have put out, a model draft, which are very interesting in some ways and problematic in others. So how do you think this feminist conversation on the UCC might go forward in the coming months?
Sorry, what did you say? How do you think?
I mean, how should feminists engage with this question going forward? Because clearly there are many other groups which have come up literally with a code.
Yeah.
Right?
So
is there something on the table to discuss? Well, how do we intervene in this process?
So that's been my so I have been part of what are called debates, where I guess I'm supposed to side on whether it should be uniform or not uniform. So, but I've taken a call that I will engage in those debates, because if you don't engage in those, so I engage in those debates by not taking those sides. I say the issue, I keep saying the issue is not about whether it should be uniform or diverse, because I mean, you don't want a diversity like a caste system. You don't want that kind of diversity, right? So we don't celebrate all forms of diversity. So therefore it doesn't, whether it's uniform or diverse doesn't matter, whether it's just and equitable matters. And how can it be equitable? For an equitable system, do we therefore need to make special provisions across, because different communities have different systems. Like, in response to Anne's question, I was saying that people have different institutional mechanisms. So, like, for example, I didn't get down to mention, there's also this thing of meher, which, so women in Muslim women in Goa register their nikah namas. That is the time they write out the meher amount. So there is that mechanism for possible enforcement. So I really think that that kind of diversity needs to be retained for possible ways of enforcement and access. So that is why, so the point is, if there is an equitable uniformity or an equitable diversity wherever it comes to it, I think we should gun for it. That is my take, and so I don't take positions against. But I take positions against the broadly against, because that's the dominant debate. So to kind of dislodge that uniformity thing, I take positions against uniformity. But I'm not saying, therefore, that automatically it just needs to be diverse. I think we need to test it from the touchstones of equity, pluralism, enabling factors that would enable people to access the family law. And again, not only speaking about women's rights in the family law, but that there are other stakeholders in the family, which could be women, but are marginalized in other ways, like due to ability, age, on these axes of ability, age, or any other, or any other forms of discrimination. So,
Thank you
so
so
in
much.
terms of drafting model codes, there is no, let's say that is why I'm very happy to have this discussion without getting too much, though I do refer back because we need to intervene in those debates as well. But there is no space in that debate to discuss the nuances of matrimonial property like I'm discussing here. Because you are now focused on trying to just stop some roller coaster that's coming, so that way.
Yeah, I think that's really well put. And yeah, sadly, a lot of of course, the debate around the UCC just seems to be completely lacking in any sort of nuance. And a lot of us are being forced to take these sort of positions. So yeah, thank you for putting what's important front and center in that way. And yeah, on that note, I think we can wrap up for today. I'm sure folks have to get back to their day. Thank you so much. This is really, really nice, Dr. Albertina. It was absolutely lovely. And I think it's given us at the project also a lot of food for thought to see, the ways we frame what we write and the ways we think about, the framing of how we think through these questions as well. Personally, I found it super insightful. Thank you so much to everyone who joined us. Please do sign up to our mailing list to receive more information on these talks. You can also follow us on Twitter and Instagram, where we're quite active in terms of sharing some of our work as well as events that we have. And yeah, we're thankful for everyone who's been attending all our talks and look forward to continue having a lot of insightful conversations like this one.
Thank you. Thank you. It was a pleasure interacting with you.
Thank you so much.